All right. Hi, everyone. As people um, continue to join, I'm just going to get us started. My name is John Reynolds. I'm the Deputy Policy and Advocacy Director here at the ACLU of Delaware, and I'm really excited to see all of you today. Thank you for attending, and a special thank you to our Amicus Society members whose support makes these continuing legal education programs possible. So thank you. And if you're interested in learning more about the Amicus Society, I know our development director, Melissa Bryson, will be more than happy to talk with you about it. And more information about how to learn about the Amicus Society, please just reach out to us and we're happy to connect you. So a few housekeeping items before I dive into the introductions. So as a CLE program, for those of you seeking, for those lawyers in the audience seeking continuing legal education credits, there will be codes displayed on the screen and read out during the course of this CLE today. And you should record those codes, keep them for your own notes, but also submit them through the method that's going to be shared in the chat shortly. There will be a form that you can input those in. As you input those codes, you'll be able to be eligible for that CLE credit at the conclusion of the program. So without further ado, I'm really excited to be joined here today by two national experts on reverse warrants and the intersection of technology and privacy. Their full bios are in the materials for this program, and they're far too lengthy for me to read out here. But to give you a basic sense, we have Albert Fox-Cahn, who's from the Surveillance Technology and Oversight Project, also known as STOP. He is the founder and executive director of STOP, and he is also a practitioner in residence at NYU Law School's Information Law Institute and a fellow at Harvard Kennedy School's Carr Center for Human Rights Policy, Yale Law School's Information Society Project, Ashoka, and TED. And so, Albert, thank you for joining us today. We also have Chad Marlowe. Chad is a senior policy counsel at the ACLU, where he principally focuses on privacy and surveillance and technology. And his field-leading policy and advocacy work has frequently been subject of national and international media coverage and critical acclaim, including in some federal court cases related to reverse warrants. So we're excited to have Chad here today too. So to kind of get us kicked off, I'm going to actually start with an overview of what you can expect from today's program. So before I kick it to Albert and Chad to share all the information, here's what you can expect. We're going to talk first about what a reverse warrant is to give us that baseline understanding of what this instrument is before we go into talk more about some of the dangers that it poses to civil liberties and the kind of constitutional analysis that is important to understand when evaluating the use of these types of warrants. After looking at those constitutional concerns, we're going to talk more about some of the specific dangers faced by communities due to the use of these warrants. And lastly, we're going to come back in and talk about Delaware's specific role in influencing how these warrants may play out in the future. And we'll wrap by having a Q&A section. I also want to note we're going to take questions throughout the program. I'm going to do my best to incorporate them as you submit them. There is a Q&A option at the bottom of your screen. Please, if possible, submit through the Q&A function. However, if you put them in the chat, I'll also try and be monitoring there to incorporate them. But without further ado, let's get to the people who you really showed up to see in one moment. But first, let's start with our first CLE code of the day. So CLE code number 1 should be visible on your screen right now. And code number 1 is 549GHQ3. That is 549GHQ3. And with that, a little bit of housekeeping out of the way, I actually have a question for Albert. So as we get started, Albert, I'd love for you to just quickly give an overview of what a reverse warrant is.
Of course, and thank you so much for having me, John. Thank you to the ACLU of Delaware, and thank you for everyone who showed up to hear about this really creepy intersection of when law and technology go off the rails and pose this existential threat to our civil rights. So, with a typical warrant, you start with probable cause. You start with evidence about a specific person. I would go to a judge if I was a, police officer, an FBI agent, and say, "Well, Your Honor, I've got evidence that Chad Marlowe has been up to no good. Here's the reasons why I need a warrant for his information." But a reverse warrant does just that. It reverses the process. Rather than starting with evidence against particular individuals, rather than showing probable cause, you begin with a digital dragnet. And there are two types of dragnets that we've seen in practice, both of which pose this really pressing set of concerns. One is a geofence warrant. And with a geofence warrant, police are drawing a line on a map, literally fencing off an area and going to the court to get an order for all of the information of the people who've gone through that space. It will capture their movements, it will capture their location history. And then from there, it can capture much more. This most often has happened with Google, where you can go to the court, get a geofence warrant, and try to identify every Google subscriber within a single room or an area as large as an entire small town. It could capture dozens, hundreds, even thousands of people's information because you're not capturing people where you have that probable cause. You're capturing information about anyone who happens to be going through that geofence. And when officers use that, they then can track the people whose data they're getting, and then eventually get their entire Google account record. In some cases, targeting dozens of people as quote unquote suspects for their movements in a single case. And this is so incredibly invasive because it really allows some of the most sensitive sites in our society to be targeted with this just new level of invasiveness, tracking every single person who goes to an abortion clinic or every single person who goes to a protest. There's so many other examples like that. But geofence warrants aren't just new and they aren't just invasive. They've also become very, very common. They actually account for the majority of warrants that Google has received from American law enforcement in recent years. They are being used thousands of times a year. And they've also led to this new type of reverse warrant, a reverse keyword warrant, where just like a geofence warrant, you're setting up that digital dragnet. You're not targeting a single individual. Instead, you're trying to find a suspect by targeting every single person to search for a certain set of keywords. That could be the address of a location that you're trying to monitor. It could be the name of a medication that you're trying to surveil people's access to. And it's just really stunning to imagine that law enforcement could get a warrant that orders a search engine to identify every single person who's Googled the name George Orwell or looked up where they can download a copy of 1984. It really is just unparalleled in the level of surveillance it offers police because, again, they're not targeting individuals. They're setting up this sweeping system that can really track anyone who is searching for those specific terms. And while this isn't being done as often as geofence warrants yet, because there are so many places in our digital lives where we're constantly searching, there are a lot of different places where this sort of warrant could be targeted to track what we're looking at online.
Howard, thanks for that overview. Slightly concerning, but overview that was the detailed in providing us that sense of a geofence and reverse keyword search and how they fall under this reverse warrants umbrella. So Chad, my next question kind of goes to you is as we think about these warrants, they sound like very, very modern things, GPS data, what we're typing into internet search engines. But I'm curious about how we now have this constitutional provision, the Fourth Amendment, which generally deals with things related to warrants, searches, seizures, written, back in the 18th century. So I'm curious about, as we start to think about the constitutionality of these warrants and the type of guidance or information we can get from the Fourth Amendment about their constitutionality, I was wondering if you could provide a quick kind of sense of what maybe the founders, as they drafted that amendment, might have had in mind, even if they had no idea what a computer was.
Yeah, so thank you to that. And first, again, thank you to the ACLU of Delaware for inviting me to join the CLE today. I think that if you think about reverse warrants as a whole, they are part of an ongoing, what will certainly be a continuing challenge of how do you apply a document that was written in the late 1700s to technologies in the 21st century, which, not for nothing, but jump 20 years into the future and all the technologies we're using today are going to seem primitive. So this is going to be an ongoing a problem for us. But it is a problem that dates all the way back to pre-Revolutionary War times. So the Fourth Amendment, generally speaking, without going to specific words, is the amendment that protects Americans' privacy, and it creates warrant requirements for when you want to penetrate a person's private life for law enforcement and other legitimate governmental purposes. But it has restrictions on warrants. Warrants cannot be for anything and everything without, as Albert pointed out, certain specificity as to the crime, specificity as to the subject, specificity as to what you're looking for. Now, the Fourth Amendment didn't just come out of nowhere. It came very specifically from Americans, or more specifically, colonists' lived experience in the years and decades leading up to the Revolutionary War. And what would happen at that time was, operating under the authority of King George, the British government in the Americas would use what were called writs of assistance, also known as the hated writs, or what we refer to them in more general term nowadays as general warrants, where they would have suspicion as to a crime being committed, most frequently disloyalty to the king. But they would not have more than that. And then they would say, okay, we have a suspicion that a crime is being committed. And then they would search, for example, an entire town like Lexington or Concord, Massachusetts. And they would be able to search every person's house and basement looking for anti-royal literature, for guns, for anything else that they might think might be indicative of someone who's not loyal to the king, and then that person would be charged with the crime. And so, again, in the conception of it is they would just have a suspicion that something wrong was happening, and then they would search everyone and everywhere for evidence of that crime. The Fourth Amendment outlaws general warrants, and it does that, again, by saying that you can't just say we want to search everywhere. You have to name where you want to search with particularity, and you have to have a person who you specifically suspect of committing that crime. So they would have to say, I think Chad Marlowe demonstrated evidence of being disloyal to the king, present to court with that evidence, and then get a warrant specifically for my basement. When you flash forward to reverse warrants, getting rid of all the technical jargon and the data and all that sort of stuff, you realize it looks essentially the same. With a geolocation warrant, you're saying, I have nothing more than an area I'm interested in. I want you to tell me every person who was in that area. So then once I can identify them, I can start digging into their lives to figure out whether or not they committed a crime or not. Same with the keyword, right? Bomb could mean an explosive device or a very long pass in football, right? So if I want to figure out anyone who searched for bomb on Google, I'm going to get every single person in, and then I start investigating them. And so when you get rid of the details around the edges, you realize that what reverse warrants are a 21st century general warrant that runs afoul of the Fourth Amendment.
Thanks, Chad, for that overview and that additional context to help us understand both how this, stitches into the history of warrants and how these types of investigative procedures informed some of the requirements we have in our Fourth Amendment to try and restrict the exact general warrant practices that you mentioned. So I now have a question kind of for both of you. I know that this is not just this question about constitutionality and reverse warrants is not just something we talk about on very educational webinars that I'm really excited everybody's attending right now. It's also conversations happening in courts across the country, including in our federal appeals courts, which has resulted in 2 different decisions around geofence warrants, specifically in the Fourth Circuit upholding in that case, although I know it's continuing to be considered in an en banc hearing, but the most recent decision upheld the constitutionality of that specific warrant in that case, while the Fifth Circuit made a general finding that geofence warrants are unconstitutional and cited the eminent scholar Chad Marlowe in part of their opinion. But I would love for the 2 of you to help explain to folks kind of how are we coming? What are some of the assessments that people are making to reach these 2 different decisions? What are these trains of thought around reverse warrants?
Albert, you want to take the 4th and I'll take the 5th? Although I shouldn't say take the 5th on a CLE. That means something entirely different. But
I always support you when you take the 5th.
Thank you, Albert. I appreciate that. You're a good friend.
No, so the Fourth Circuit was the first federal appeals court decision we got on geofence warrants in the country. It came out of this case from Virginia called Chattree, where there was a bank robbery in this small town, and the police set up a geofence warrant that was large enough that it not only captured the location data of everyone in the bank, but people in nearby buildings, people in nearby businesses, people in a nearby church. And it was this really overbroad geofence warrant that raised so many of the policy issues that Chad was describing, that it effectively was a search of anyone who happened to be in that area of the small town, whether they were the teller, a customer who was there when they was being robbed, or potentially even a suspect. And so the district court found that this was unconstitutional, that the search, that there wasn't that sort of particularity that, Chad described requiring for other sorts of warrants, that there didn't have that linkage between one specific person who is being targeted because of the evidence against them and the search itself. But unfortunately, a panel of the Fourth Circuit reversed that. They actually overturned the district court, and they upheld the constitutionality of the warrant. They didn't find that this amounted to a search for the purposes of the Fourth Amendment. Because, there's a lot of data that we hand over every day to companies. Data about our banking, data about our phone calls, data about nearly every aspect of modern life. And so turning to this, really problematic and, internally inconsistent set of cases around third-party doctrine, the court found that people didn't really have a protection against having their location data searched the way it was through the geofence warrant, and also finding that, basically not finding the same particularity issues as the lower court. But luckily, they don't get the final word on it. The amazing lawyers at NACDL, the National Association of Criminal Defense Lawyers, they've been working on this for years, and they are actually going to try to overturn that decision by taking it on up to the entire Fourth Circuit for what's called en banc review. And there was also a very helpful dissent in that case, which really highlighted a number of the really chilling implications of this sort of decision. But Chad, luckily, is going to be able to get into some of those arguments when he describes what happened in the Fifth Circuit.
Yeah, thanks, Albert. So the Fifth Circuit case, which was U.S. v. Jamar Smith, I won't go too much into the details of it. It involved the robbery of a postal worker, but again, same concept with the geofence warrant, just trying to scoop in cell phone data. What I think is particularly interesting about the Fifth Circuit's decision is it had the benefit of coming after the Fourth Circuit's decision. And despite leading into a lot of its sentences with respectfully and other compliments for the Fourth Circuit, was always followed by, but you got it wrong and here's why. So it's not only a beneficial case, which ultimately ruled that the use of reverse warrants is unconstitutional because they're general warrants, but it also provides a kind of interesting live rebuttal of the Fourth Circuit. And I would imagine, I'm sure, Albert, you'll agree with this, that if the appeal does go up en banc, that Fifth Circuit case is going to be quoted liberally by the parties who lost in the Fourth Circuit. Essentially, what the Fifth Circuit did was two things. First, they kind of dismissed out of hand the Fourth Circuit's conclusion that there was no actual privacy interest in the data because of the third-party doctrine, because cell phone data was kind of willingly turned over to Google. What they said, which I think, in my personal opinion, is exactly right, is just because someone clicks a box on their phone saying, I'm going to share data, does not mean it is thoughtful, does not mean it is well informed, does not mean that they understand the actual implications of it. If I tell, WeatherBug, they can track where I am in order to tell me the weather, the average person doesn't realize that location data is then going to be captured and potentially used by the government to know where I was. So the Fifth Circuit kind of, and I think rightly so. I think that, there is a notable difference between, when the third-party doctrine was developed, when someone was actually giving specific records to a specific bank for a specific bank account for that purpose of that transaction only, very different than the way we live in our digital lives where we're just sharing data all the time. And I think the Fifth Circuit got it right, that people in modern times share data without actually understanding the implications of their doing so. So having dismissed that and said that cell phone users actually do have a privacy interest in their data, they took one look at the general warrant and said, reverse warrant, and said, this is exactly what a general warrant looks like. Like, you have no particularity. You're not naming any specific person. You're not claiming why you think the company you're subpoenaing is likely to have data relevant to a particular crime. There's none of that. And then, kindly deciding to cite a blog of mine and justifying their final decision, said, this was unconstitutional. And I noticed there was a question in the chat about, and Albert's right, like, this is gonna, in the Fourth Circuit's gonna go en banc, and whether or not it's on the basis of those two cases that it goes up to the United States Supreme Court, or there's going to be another case, this is going to land in the U.S. Supreme Court eventually. And someone asked a question about, how Supreme Court interpretations of constitutional originalism might impact this. So there's two answers for that. The surfacey answer is that originalism leads us to a pretty clear conclusion that these are general warrants. Because I think that, again, when you get rid of the modern trappings around how these work, they're consummate general warrants. But what I would also say as an ACLU lawyer is that originalism is often driven by an intended result. You come up with the result you want, and then you figure out a way to suggest that the founders would have found that result. So, in this case, you can say, well, the originalists were only focused in on paper warrants. They couldn't have conceived of electronics, therefore it couldn't have covered that, which would be basically a way of saying nothing in the 21st century applies to constitutional protections because they couldn't have envisioned that. So if they want to go that way, they could certainly go that way, or they could say that get rid of the trappings, and this is exactly what they were talking about. So I think that
Chad, motivated reasoning in originalism. It's shocking to even consider it. I just wanted to add one point to that, which is, we have seen some good work from the Supreme Court, from the Roberts Court on this sort of issue. So the politics of it may not break down the way you expect, because, as the justices themselves use these devices more and more in their daily lives, they become more attuned to the seeming invasiveness and potential abuse of having these sorts of tracking technologies. And so, for example, there was an earlier case called Carpenter that Roberts wrote the decision on, which said that you couldn't, collect a lot of cell site location data under this theory of the third-party doctrine. And so there really is an entry point for this Supreme Court with, to find a path through some version of originalism to actually expand these protections to meet the moment. But clearly, it is much easier to predict the type of rhetoric they will use than the actual outcome they'll reach.
Yeah, and I think that's a good point, Albert, in that when this case goes to the Supreme Court, it may actually not come down to the issue about whether a reverse warrant is a general warrant, but whether or not the Supreme Court is willing to scale back the third-party doctrine even further, like it did in Carpenter. Again, Albert's exactly right. That was a John Roberts decision. But, every time the Supreme Court kind of reels back the third-party doctrine, it feels like they do so with great hesitation. But again, they did it in Carpenter. So I think that, my sense, and Albert, I'm interested in what your thought on this is, but my sense is that this feels like it might come down more to a third-party doctrine analysis to turn on that than whether or not the reverse warrant is actually a general warrant.
Yeah, no, we see the Supreme Court sort of like it's like they've got a very expensive truffle and they're carving it away with a razor blade, just slice by slice, taking away from the third-party doctrine, because clearly this started as a bank records line of cases in the 70s, like you were saying, and it grew to capture almost every aspect of our modern digital lives. And so clearly they recognize that's gone too far, but they are so nervous about pulling back on it. When they were writing about it in Carpenter, they're like, well, we're striking down this collection of cell site location data without a warrant for more than a week, but we're only dealing with this one fact pattern. And they were very reluctant to enter the sort of sweeping space that they do with so many other areas of constitutional protection. So I think that it may be the situation where you actually need a couple of decisions about different types of geofence warrants and reverse warrants that incrementally push back on different elements of it before you get a wholesale ruling that they are completely unconstitutional. Knock on wood.
So Chad and Albert, thank you again for outlining these kind of different approaches to it, as well as anticipating and thinking ahead to what additional considerations might be if/when this issue were to go before Supreme Court. I'd like to transition us now to talk a little bit more about, the on-the-ground realities of how reverse warrants are used, especially over the past couple of months and years, how they've started to be used to target kind of specific communities or specific groups of people. But before I do that, we did have another question in the chat that I think would be useful before we engage in that conversation. And it's, when geofencing happens, are they, law enforcement, just looking at data, or are they actually searching large swaths of people? I don't know if one of you would be willing to chime in on that before we start to talk about how, in reality, that's been looking over the recent times.
Yeah, so it varies, right? When you see these geofence warrants that are approved by trial courts, they don't always take the same approach, but a typical geofence warrant might be, hey, here's a site we're investigating. We want everyone's data over a 4-day period who went in or near that site. And if anyone goes into that geofence during that 4-day period, we want all of their movements over the course of a week. And then they might get this giant database of the movements of anyone who crosses into that geofence, with some amount of error because the location data isn't perfect. And then you would have that as a starting point to sort of reconstruct people's movements. And then officers go back and they say, oh, for this person or that person, I actually want their movements over a much longer period of time, like a month or a couple months, or it might go all the way to saying, hey, Google, give me their entire account. And so in some of these cases where officers are quite sloppy, I've seen them take the approach that anyone who went into that geofence, they just go to step 3. They just say, hey, Google, give me their name, give me all their account ID information. But not just that, give me their entire Gmail archive, give me all of their messenger history, give me literally every scrap of information that you have about this person. And Google is a particularly invasive platform when you're talking about geofence warrants. But if it's going to Lyft or Uber, you can get someone's travel history. If it's going to any number of other companies, it can really get to quite detailed records. So it's really doing both. It's searching people and it's searching data. Chad, not sure if you have a different take.
No, certainly not a different take. And I should note, by the way, that the first time I ever heard of a reverse warrant, Albert is the one who said, Chad, I got something you got to be worried about. So literally the first time I ever heard it was from Albert. So I would certainly never disagree with your analysis. I would just add that one of the important things to remember about reverse warrants is they are both a privacy violation, but really they are the beginning of a domino effect of privacy violations, because if you are looking for someone who you think has committed a criminal act, right? And it could be, a criminal act that all of us find, offensive, murder or something like that. Or it could be, one of your modern crimes, like trying to get abortion care or gender affirming care, things we actually think are societal goods. But once they identify a group of people who may have committed a crime because of their location or because of a keyword they entered, you don't stop there, you start there. You then have to dig into a person's personal life to figure out whether or not they are or not the criminal suspect or suspects you're looking for. So I think it's really important for when you gasp at the idea of the data that these reverse warrants are gathering, take another deep breath, because another gasp is coming, because again, it's just the beginning of what needs to be more and more privacy violations. And because of that, people like Albert and I often say that these reverse warrants turn everyone into a criminal suspect simply because you were in the wrong place at the wrong time, or you entered the wrong search word at the wrong time. And that's certainly not, I think, reflective of American general principles or constitutional principles.
No,
So
I was just gonna add, like, you have to think of surveillance, like Chad was saying, it's both things. It's an invasion of privacy, it's an invasion of autonomy, but it's often the first step towards police violence. When you think about where these investigations go, don't just think about all of the data that's being seized online. Think about the officer that is stopping a car on the side of the road, or knocking down someone's front door, or even, kneeling on them, placing them into handcuffs. These are the byproducts, the eventual places that surveillance takes us, because it just keeps building. And so when we think about the communities being targeted, it's the same communities that have been systematically targeted and over policed for as long as we've had police in this country. We know that communities of color, BIPOC communities, are targeted far more often with police surveillance, with policing generally. And that's going to hold true with geofence warrants. We know that protesters, including Black Lives Matter groups, have been targeted by these sorts of geofence warrants. Even, in Minneapolis, in the aftermath of the George Floyd's killing in 2020, we saw geofence warrants being used to target those who are taking to the streets to raise up their voices against police violence. We know there's risks to immigrant communities, undocumented individuals in particular, from ICE's abuse of the practice. So really, when we think about who is most vulnerable and where these are most likely to be used, they're not going to be used to target white collar criminals and to target wealthy people in privileged positions. It's going to be the same pattern of abuse we've seen for time immemorial.
Yeah, and the only thing I would add to that too is, and again, without adding any value judgment to it, they were also used against January 6th protesters. And I only raise that because one of the good things about advocacy around reverse warrants is it's not a partisan issue. I think everyone across the political aisle has a concern with them. They may be different concerns, and people who are pro-police are going to love them no matter what. But this is one of the few issues in 2025 that people can work on and kind of avoid partisan wrangling. I think that there's a concern for everyone with these things, and hopefully working together, we can address them in an effective way.
That's so true. And we see this in red states and blue states. There's just this severe, fear of the power these put in the hands of individual officers, and the just potential for abuse.
So Chad, you just talked about how this is, and Albert, it covers across the political spectrum, but these warrants can also be used in relatively politically targeted ways. And I was wondering if maybe one of you could talk about how the interactions that we're seeing about how certain laws that have been referenced, passed in Texas, Florida, Idaho, that are criminalizing conduct that is legal in Delaware, how then, I guess, why should Delaware, beyond just perhaps believing in those values or those rights to cover all Americans, beyond just that, why should Delaware kind of have an interest in this idea of search warrants, reverse warrants in particular, and kind of our interaction with them?
Yeah, so I mean, I would say, and John, we've worked together a lot on this for the last couple of years. When it comes to worrying about reverse warrants, I think once again, Delaware should be considered the first state. And I want to give a couple of examples that's happening in the world. John and I, the ACLU of Delaware, and many allies across Delaware have been working for a couple of years on this. And what we've been saying is, Delaware is particularly attractive for these warrants because it is the home to so many corporations. And when you are seeking to serve a reverse warrant on a corporation, one place you are always allowed to serve that warrant is in a company's place of incorporation. So if you have a state that is trying to enforce a law, let's say it's an anti-abortion law or an anti-trans law, and they don't have minimum contacts with the company that they're trying to get the data from, they've got to find another place to serve their warrant. And any company that is incorporated in Delaware, that reverse warrant is likely to land on Delaware's doorstep. Now, again, John, as you well know, for the last couple of years, we've been kind of rubbing our crystal ball and talking to you about what a frightening future might look like with reverse warrants, but it has arrived, and we know it has arrived. I can give you two examples of them. The first is, I'm not sure if it was last year or the beginning of 2023, Idaho passed a law making it illegal for a person to aid a minor in getting abortion care in another state. At the same time, last week, Louisiana charged a New York doctor who has never been to Louisiana with violating their abortion laws by providing the morning after pill to someone via telemedicine in Louisiana. The point there is that states that are deciding to criminalize abortion or gender-affirming care or other behaviors that may not rise to the level of illegality in Delaware are not going to stop at their borders when it comes to prosecuting their cases. And so Delaware simply needs to understand that, I'm reminded of that everyone thinks this is from Spider-Man. It's not. They ripped it from a philosopher several centuries earlier. But the idea of with great power comes great responsibility. Delaware has benefited enormously by being home to so many corporations in terms of its tax revenues. But from that benefit comes a responsibility not to be the nation's Achilles heel when it comes to reverse warrants. And so I think that unless Delaware wants to become known as the state where your data is at risk, and I will add that corporations who incorporate in Delaware do not want Delaware to become that state, Delaware is going to have to act proactively to prevent that from happening. And one way in which to do that is to ban reverse warrants in Delaware so that people from other states cannot come to Delaware and ask for their reverse warrants to be domesticated.
Yeah, and I just think people need to take a moment to really let this sink in. Look, in a pre-Roe America in the 1970s, there was no way for Texas to station a Texas Ranger outside of every abortion clinic in Delaware, every doctor providing gender-affirming care, and monitor if Texas residents were going in. There was no way for them to really monitor activity on a large scale that was happening outside the state. But in a post-Dobbs America today, there is an unprecedented ability for state law enforcement in anti-choice states and states that are, waging a war against gender affirming care to monitor their residents when they are getting care outside of state, and to monitor those who are providing telemedicine support to people in their jurisdiction. This is a constitutional crisis on a scale that we really haven't seen since the debates of the Fugitive Slave Act back, prior to the Civil War. And so it raises fundamental questions about the level of civil rights protections, the level of due process, the level of just integrity for the legal system in Delaware, and whether or not it is willing to take the steps necessary to protect its residents and ensure that other states aren't able to effectively commandeer the Delaware legal system and use it for their own ends.
Yeah.
It's a massive challenge.
Yeah, and beyond that, it's not just people coming to Delaware. It can just be the fact that they are engaging in gender-affirming care in a different state, but that data is held by a company incorporated in Delaware. So again, it's, some legislators will be like, my only obligation is to worry about my state. But legislators who are heroes care about people no matter where they live. And I think this is an opportunity for people in Delaware not only to protect their own people, but to protect people who, to put it bluntly, aren't lucky enough to live in Delaware, aren't lucky enough to live in a state that protects their choices, whether it comes to reproductive rights or gender identity. And so this is an opportunity for Delaware not only to step up to protect itself, but to protect the entire country in what Albert properly noticed is an extraordinarily dangerous time.
And John, I know we need to get to another point, but one thing I would be remiss not to add, it's one of the few, look, I sue tech companies a lot. They're not always on the same side as me, but this is one of the glorious times when the tech companies and the civil rights advocates are on the same side. Like, this is such a boost for businesses. Like, I know right now there's a lot of folks who are in high risk scenarios who are moving their data overseas. They're looking for companies who are based in Switzerland and jurisdictions that are going a long way to protect their data and protect their privacy. If Delaware can create this model of protecting people's data and ensuring that when they use a service incorporated in the state, that it isn't a free-for-all, where it isn't subject to these sorts of geofence warrants and keyword warrants, it starts to go a long way in providing peace of mind to users and an incentive for even more companies to incorporate in the state.
So before we continue our conversation, I have to do a little bit more administrative work here. It is time for CLE code number 2. And CLE code number 2 for all of my lawyers seeking credit out there is, one second. Code number 2 is 671 FBA2. That is 671 FBA2. And with that bit of administrative work out of the way, we have a few questions coming in through the chat. And before I dive into some more Delaware specific ones, I realize that I think there's a few questions going that relate to some of the issues you're talking about. And one of them that just came in recently is about the idea of data, and are reverse warrants the only way and only thing that Delaware needs to be focusing on? I know that's the topic of today, but the question came in about, are cops paying tech companies to get this data with or without a warrant? And is that an additional concern that maybe is also something that needs to be considered as we think about corporate kind of homes in Delaware and the power that Delaware has?
Yeah, and so unfortunately, as much as I would like to be able to say, if you pass this one law, you fix the problem. Like, the world rarely ever works that way. There is absolutely a problem right now in that more and more police are doing a complete run around the Fourth Amendment by not even bothering to get a warrant, but instead just going out and buying the data that they want on a person from data brokers. There is a bill that was run on the federal level, but if anyone wants it, we've got a state and local version of it from the ACLU called the Fourth Amendment is Not for Sale Act. And basically, the Cliff Notes version of that is, it says to law enforcement, you need to get a warrant. You can't just evade warrants by buying data. And this is very important because with this loophole in place, the police just have the ability to say, you know what? I don't have probable cause. I don't have any particularity, but that's all right because, and a matter of fact, I may not even have a crime. I mean, I think that, one of the things we're seeing with the current administration is you don't actually have to be doing something wrong to be targeted. And they can just decide, you know what? That Albert Fox Khan is doing a lot of things that we don't like. Let's just buy every bit of data we can on him and comb through it and see if we can find something. Find something illegal, maybe, not likely, but just something to humiliate him, embarrass him. And so that's what we're looking at. So, Fourth Amendment is Not for Sale Act is another thing Delaware can do, and there's probably a dozen other things too. But there is no silver bullet, and so we're going to have to build the wall one brick at a time. So definitely, if you're looking for a second brick, Fourth Amendment is Not for Sale Act is another one.
But crucially, just to make clear, in the geofence and reverse warrant ban, it also blocks police from buying that data, that specifically that geofence, that geolocation data. So they can't sort of replicate a geofence warrant by doing an end run with public money rather than getting a court order. But Chad is completely right. It's part of this broader movement to block the purchase of our data by law enforcement, because there are companies making fortunes by selling your data to the highest bidder, including to law enforcement.
Yeah. I appreciate the assumption that they were going to pass exactly our version of the bill, and he's right. If they pass our version, those purchases are outlawed. But one never knows when you put a bill in what it's going to actually end up as. But to your point, Albert, I do think that is a critical element of banning reverse warrants, is also to ban purchases for the data. Otherwise, you're gonna end up getting the donut, but also getting the whole.
So thank you both for that. And I think as we then think about, we got some questions coming in about what individual people can do to protect their own data. But before we perhaps get to those, I'd love to also think collectively. We've talked about these laws, we've talked about kind of legislative opportunities, but I was wondering if you could provide a little bit more information about, legislatively, how does this work? Like, if Delaware wants to make these decisions, what are some of the key things that we need to understand as we think about legislation? Can we just pass laws that deal with some type of conduct to address this overall concern? Or is this really, how do we frame this? Because I know, as Chad was saying, you start with language and we have the negotiation come in. And what we've talked about here is that this issue with reverse warrants is impacting civil liberties at its core in many ways, and is also used to target other aspects of civil liberties specifically. And so I'm just curious, as we think about legislation and important things from both of your perspectives, as we think about restricting this use and protecting privacy, what are some really key things that people should understand if they want to advocate for these laws?
So I'll just name one thing, and then I'll kick it to Albert, who probably has 10. But just one thing from the work that we've done, and this is kind of politics and policy kind of coming together. But some people have said, can we carve out certain reverse warrants, or can we just refuse to domesticate warrants, which is when a warrant from another jurisdiction comes up to Delaware. The challenge with trying to do this in any sort of piecemeal sort of way is that if a warrant, and let me use Florida as an example, if Florida issues a warrant because someone has, let's say they have fetus personhood in Florida. I don't know whether they do or don't, but they're probably heading in that direction knowing Florida. And someone goes across, goes to Delaware to get an abortion. They could charge that person with child trafficking or attempted murder. There's a lot of laws that they could try to drum up. If they bring the warrant to Delaware and say you need to domesticate it so it can actually be effectuated in Delaware and a Delaware corporation, if Delaware prosecutors were to say, you know what, this looks like this is targeting someone seeking abortion, we're going to refuse to domesticate that warrant, you are waving a red blanket at a bull. Ron DeSantis is going to, first of all, he's going to say very quietly, thank you, Delaware. You just gave me red meat for my base. And then he's going to say, if Delaware is going to make political judgment about Florida's laws, Florida is going to make political judgments about Delaware's laws. And here's what it's going to sound like. We don't like any of your laws. We don't like any of your warrants. We're not domesticating any Delaware warrants in the state of Florida. We're done. And he has just gained huge political support, all the press he wants to the audiences he wants, and that's the retribution. On the other hand, if Delaware passes a law saying we can't use reverse warrants, they are not a tool that exists in Delaware, and then Florida comes up, then it's a different conversation. Then it's saying, I'm sorry, we can't domesticate your warrant because even we can't use reverse warrants. They just don't exist here. And it's not as politically antagonistic, and it's more effective. So you kill two birds with one stone.
Yeah, and on the strategy and messaging side, one thing that I think is really crucial to talk about that we haven't really touched on yet is just how these warrants are incredibly ripe for abuse, but they're really quite bad as a policing tool a lot of the time. There's a growing number of cases where people have been falsely arrested, wrongly held in prison, sometimes put in jail for days, even weeks, because of geofence warrants that led authorities astray. Because when you're looking at someone's movements on a map, it's easy to have this confirmation bias where suddenly everyday travel patterns look suspicious or like evidence of a crime. There is a man down in Florida. Yes, we're picking on Florida a lot today, but with good reason. And he was seen as being a prime suspect for this house burglary because they saw him suspiciously circling the scene of the crime, going in circles over and over again. What they didn't realize is that he was a long distance bike rider who was getting in his miles to preparing for a long race. So much of this is in the eye of the beholder. And we also see cases like a man in Arizona who is wrongly accused with murder for a case for this crime that happened miles and miles away from where he was, just because there was a device that was misassociated with his account that was near the scene. And so they, when you think about the way that geofence warrants work with a lot of criminal cases where you're looking for one individual in the scene, there's a lot of potential for error. But when you look at their misapplication at protests, at reproductive health facilities, at other large-scale gathering points where you have a high throughput of individuals and you're not trying to find that needle in the haystack, where you're trying to actually target the haystack, like that really disturbing set of cases where it's being abused, they actually are much more effective in those cases. So that's really just such that's something that we've seen lawmakers really respond to just as they're thinking it through.
Yeah, and the one
Chad,
thing I would say,
before you chime in, I actually have kind of another question that kind of relates to the point that Albert just raised of the idea of trying to develop a haystack to find the needle versus target the haystack. And one of the other questions we have, please keep them coming, folks, too, is this idea about the particularity requirement. So the question is, isn't it true that law enforcement must state with particularity the area to be searched within a very specific time range, and afterwards the court must balance the request against potential privacy intrusion? I was wondering, as you think about what Albert was just saying and think about the context that you shared earlier around the different approaches to assessing this, I guess how would you respond to that question, this idea of courts balancing the particularity versus privacy interest and how we're seeing it interact in this haystack needle type of situation.
Yeah. So the one thing I was going to say quickly before I turn to that question is, the funniest thing about to me about the pushback in Delaware against banning all reverse warrants, it reminds me of like the curmudgeon-y person who says, the restaurant's food was terrible and the portions were too small. Like, Delaware police recognize these warrants don't work well. They say we barely use them, but at the same time, they want to have them anyway, even though they say they're bad because they simply don't want to give up tools. But what I would say with particularity is it's not just limited, the requirements are not just limited to a location. So you can define a crime with particularity. I know exactly the crime. It was robbing that gas station, right? And you can name an area of interest with particularity, right? It's a half mile around the gas station. But that's not the limit of the Fourth Amendment's rule. You have to have particularity as to the suspect as well. And you have to have particularity as to say that you think there is a likelihood that a search of what you're searching is going to reveal evidence about the specific crime and the specific person. So a lot of times, law enforcement who's trying to fight bans on reverse warrants will say this. They will say, oh, but we have particularity as to this one thing, but it is not a one-part test. There are multiple things as to which you have to be very specific. And so, I will concede that if there's a robbery of a bodega, that you're being particular as to the location, although I'm sure, as Albert will tell you, even when you do that, you're going to grab in things that aren't very particular. But even if you could do that, that is only one element of the Fourth Amendment standard. Checking one box does not equal checking all the boxes.
And even more egregious than that, in a lot of these cases, you are looking for maybe one suspect, maybe two suspects, and yet you're getting the location data for dozens. And so you're not only failing to particularly describe the person that you're seeking, consistent with the Fourth Amendment, you know that at least a portion of the people, if not everyone you're searching for, is completely innocent. Just by definition, because you have more people whose data you're getting than who are suspects. So, the Supreme Court has dealt with this previously when it comes to analog searches. They had a case years ago where, police had very strong evidence that there was a person in a bar who is, dealing drugs, and they had particularly described the offense, dealing drugs. They did particularly describe the bar. But the court said, yeah, that's not good enough. Because when you were searching each and every person in that bar, you could not particularly describe the reason why you considered them and only them a suspect. And in fact, you knew that most of the people in that bar had not committed any crime whatsoever. And this is no different. The problem is that we just see that when the state is abusing digital power as opposed to analog powers, the courts can often be very slow to keep up.
And so I guess one other thing, just to kind of put a point on some of the things you just raised too, is the example we talked about here is a lot of it's been about geofence. But one of the other things I know that this could also be used for, and correct me if I'm wrong, is for something like identifying a specific Planned Parenthood or abortion service provider and saying, hey, Uber, I'm Idaho, and I know Washington's just across the border and they have a clinic over there. Can you, Uber, give me every person who entered the keyword of the location for this clinic? This is the other thing we're worried about too, right? In addition to not just geofence and not just using that, but using it in a way of capturing everybody who searched it and doing it and using that to do the other invasive tactics that you all described earlier.
And not just that, but hey, Google, give me the name of everyone who Googled mifepristone. Give me the name of everyone who, was searching online for a website that could ship them an abortion medication, or send me, or everyone who, was searching for information about this protest. So yes, we are talking about these digital dragnets in physical spaces, but they also can be cast in much broader terms when thinking about these keywords.
Yeah, and in a way, as bad as the geofence warrants are, the keyword is even worse because it's like a thought police. If the American, information about technology filters out. It may filter out slow, but it filters out eventually. And if the American public were to learn that every search term you enter in the internet can be discovered by the government, I mean, you can be searching for gender affirming care because you want it, or because you're doing a paper on it, or because you have a friend who's interested in it. But if you have a sense that you might be caught up in a criminal investigation because you enter that, it is not an unreasonable response to not enter it, to not learn about it, to not think about it, to not talk about it, to not associate around it, all because you are afraid of ending up the target of a government who views you as an enemy. So, so again, I think, and it's always important when you deal with anything that impacts privacy to realize that privacy is the gateway to all the rest of your rights. So if these keyword warrants are allowed to be used, you end up impacting people's First Amendment rights in ways that are far more profound, or at least as profound as their Fourth Amendment rights.
Well, Chad and Albert, thank you for the very engaging hour. I apologize to the attendees for some of the questions we weren't able to get to, but thank you for submitting them. As you can tell, there's a lot to talk about here. I know that I welcome anybody who's interested in wanting to continue the conversations around reverse warrants. This is something that ACLU in Delaware has named as one of our priorities in our firewall for freedom work over the course of these coming months and during this session. So if you're interested, please feel free to reach out to me. I'll put my email address in the chat in a moment for folks who want to hang on. But for everybody else, I wanted to say thank you for attending. I hope that it was an informative hour. And thank you again to Chad and Albert for sharing your expertise.